Kill the Boer, the infamous song that triggered litigation against Julius Malema and his economic freedom fighters. Mark Oppenheimer was the advocate who represented AfriForum and later us, the Free Market Foundation, and our Rule of Law project in the court. We're delighted to have you join us today here at Northwood's House to discuss the intricacies of the court proceedings, your experience behind the scenes, and also what this litigation means for jurisprudence in South Africa, for our legal system, the independence of the judiciary. Unfortunately, the Constitutional Court has refused to hear this matter on appeal. I think it is a black mark against that court, and we'd like to discuss the implications of this landmark case and why the Constitutional Court has declined to hear it. I'm joined by my colleague Martin van Staden, who's going to be participating in this conversation. Mark Oppenheimer, take us behind the scenes of this very important case and what triggered it.
Well, the trigger was really the murder of Brendan Horner, who was a young farmer who had been killed and his body was put on display. And at the arraignment where those who were accused of killing him were present, there were a number of different organizations who were protesting farm murders, who were very concerned about the sort of heightened levels of violence, and then also the EFF. And the EFF at that proceeding sang two different songs. So the one being Kill the Boer, and the other one being a song sung by Ndlozi, which translates as Burn These Boers. And quite soon after, there were fires about 3 hours away from the region on farms. And AfriForum, who I acted for in this case, were quite alarmed about this. Kill the Boer had been sung on various occasions by the EFF. There had been prior litigation when Julius Malema was part of the ANC Youth League. He had sung the song, and there was a finding at the time that the song constituted hate speech. The matter was taken on an appeal, and there the parties agreed to a settlement where they said that they would refrain from this sort of conduct going forward, and they would counsel their members to refrain from this sort of conduct. Interesting enough, in that original judgment, Judge Lamont had noted that Julius Malema would sometimes sing a variant of the song, which was Kiss the Boer. And for many years afterwards, when Mr. Malema joined the EFF, he would sing Kiss the Boer. And the original defense when we brought this litigation against them was to say, we don't ever sing Kill the Boer, we only sing Kiss. And one of the things that happened during the proceedings was every day we'd have a mob of EFF protesters outside of court. So much so that we couldn't go through the usual entrance and exit at court. We had to kind of be smuggled out through a secret entrance where the judges go. But on one of the occasions we got mobbed by this group, and they quite evidently saying, "Kill the Boer" at us. There was no kissing, just lots of talk of killing and lots of miming of shooting us. And we filmed this. And we then brought it up, I think, on the second day of the matter to sort of raise two issues. The one is to say, look, we have to run this matter without being abused. We cannot endanger our lives in an ordinary court proceeding. This is contemptuous of the process. And also, their defense has been, we don't sing the song. Well, here's video of them quite clearly singing the song. And there's a scene of me cross-examining one of these guys who was there after having showed them the video. And the first thing he says is, before I answer your question, I need to get some sort of advice from one of my compatriots over there, to tell me what I should be saying. And the judge intervened and said, no, you can't do that. You actually have to sort of, testify as to what you've seen. And it was a rather humiliating moment for the EFF, but they then kind of ran with this idea of, well, there's nothing wrong with singing Kill the Boer, and they very much accepted that that is what they, should be free to sing. One of the things that we did in the pre-planning of the litigation was to think, what is the purpose of running a case like this? One of the driving ideas for us was that courts are a stage. The matter was filmed. It's probably one of the most sort of covered trials of the last 5 years, I'd say. That idea of filming court processes really starts with Oscar Pistorius' case, where there was a kind of separate legal battle about the right of the press to be present in these things and the public interest in these matters. And there's something quite useful about the public being able to understand what happens inside of a court, because ordinarily all that you have is the court's judgment, and that's very rarely being read by the public. And so sometimes you have court reporters who are writing things up, they may distort things, and so having a full record of the footage, very important to us. And we also took the view that farm murders had become a very taboo topic, where the press is in a denial mode about them, and refuses to cover the brutality of these murders, the extent of them, how disproportionate they are in terms of other crimes. And so in the 9 days that we ran our trial, about 6 days talk about farm murders. And so that was an important issue. Some people sort of misunderstood what the purpose of the trial was. So the test in our law to work out whether something is hate speech derives partly from our Constitution and partly from the hate speech sort of legislation, being the Equality Act. And so our Constitution says you've got this very rich free speech right, and there's 3 exceptions. First is propaganda for war. The second, the incitement of imminent violence. And the third being the advocacy of hatred on the grounds of race, gender, ethnicity, and religion, and that constitutes an incitement to cause harm. So if you think about that last category, you've got to be calling on people to go and perform a harm against a group. So from a kind of economical view, Kill the Boer is about as economical as it gets. You're saying, here are an ethnic or racial group, Afrikaners, you should go out and you should kill them. So on that high threshold test in the Constitution, it would seem obvious that it meets the requirement and had been found so by the Equality Court before, and by the Human Rights Commission itself. The equality legislation had sort of added in some additional parameters, so it went beyond the 4 groups. It included other protected groups, sexual orientation, for example, albinism, things like this. Had initially included hurtful speech. I ran another case called Kwalani where we struck down hurtful speech on the grounds that it was too restrictive of a free speech right. But you had a bifurcated test where you had to show that there was propagation of hatred, and either that there was an incitement to cause harm or that the words themselves were harmful. There was no requirement that you ever had to show a causal link between the speech and real acts of harm in the world. This was something that had been tested in Kwalani. Just to give you a bit of background, John Kwalani was a journalist, quite an active anti-apartheid journalist, and quite soon after the Constitutional Court had produced a judgment requiring Parliament to produce legislation allowing for gay marriage, he had written an article where he said, I pray that politicians will have the balls to change those parts of the Constitution that allow a man to marry a man and ditto a woman. And he was charged with hate speech. He was found guilty in the Equality Court. I acted for him in the Appeal Court, where the legislation was struck down as unconstitutional. The Appeal Court took the view that he couldn't then be held liable under it.
The legislation being Papuda.
And they struck down the clause in very broad terms and replaced it with the constitutional clause. It went on appeal to the Constitutional Court, who then did a sort of drafting exercise in a way, one that the Supreme Court of Appeal had resisted. When the Supreme Court of Appeal, I have to say, really took the matter very seriously. We were there until after 6 o'clock at night, was interested in trying to get the law right, and had asked, all of us for our inputs on what it could be. And I'd sort of suggested, well, you could strike out this and you could add in an and they said, we're not legislators, we can't do that. We see this thing as a wholesale problem. We're striking it out and replacing it with the constitutional language. The Constitutional Court said, we don't mind a bit of drafting. So they struck out the hurtful bit, but kept the disjunctive. But made a finding that a causal link is not required. But there is still an important role for expert evidence and for background considerations to understand where is the speech being uttered. Speech isn't just uttered in a vacuum. One of the reasons why Kwalani matters is that we modeled our case on how the Kwalani case was run in the High Court, which was to basically have different kinds of views on the speech. So having an expert talk about, what does homophobia look like in a society? There was individual testimony of black women who were correctively raped in townships and the effect that homophobic speech had on them. The idea that there was a tinderbox environment where I think he was publishing through the Sunday World, where that paper was read. And this evidence was taken very seriously by all of the courts. In particular, the personal evidence is mentioned in the judgments of all of the courts. And they all felt this sense of, when you look at someone's personal story and you see what they endured, because, they said, not even though there was no admission that the speech led to a corrective rape, they said the fact that there are corrective rapes is a reason for us to be concerned about the speech. So we tried to replicate that evidence in Kill the Boer. And so we had evidence from Dr. Ansara, who'd written the book Kill the Boer, talking about the epidemic of farm murders, going into the numbers. So how prevalent are they? How do they compare to other crime stats? Going into the nature of the crimes. So there's a sort of line that, well, this is just ordinary crime and South Africa is a sort of dangerous place. But he pointed out, and by the way, this has just been echoed by the American government, who'd sent out a body to investigate what happens in rural farm murders, and they came to the same conclusion, which is that there are high levels of brutality and torture, that often the people who are being murdered and tortured are very elderly, they're isolated, and almost nothing is taken. So that implies that there is some other element going on here. There's an element of hatred. The American government picks up some of what we'd picked up on, which is that Kill the Boer was used as a phrase, either chanted by people in the act of killing, or written on the scene of the crime. And one of the most sort of like devastating stories that stuck with me for many years, a story about a mother and a daughter who were brutally murdered and raped, and Kill the Boer is written in blood over their bodies after the breasts had been cut off and their bodies brutalized by broken bottles. So we said that's the environment in which we're operating. We then had evidence from a counsellor who worked in these communities, and he talked about the impact that these attacks have, not just on the individuals who are attacked, but on the community at large. That often what you had was quite good relationships between farm workers and farmers, that the farming was seen as integral to the community, and these attacks would often come from outsiders. There's a sort of line that it's disputes between labourers and the farm owners. That was quite rare. So often you had outsiders coming in, and it would break down the levels of trust. Often people who were being attacked were the farm labourers themselves. They'd be tied up and brutalised. And so he talked about that sort of social effect. And then we had evidence from people who had survived farm attacks. Often their loved ones didn't. And so all of this was to provide the context for the speech. And what was interesting was that every day we had a phalanx of reporters in court, and you had what we'd see and what was broadcast on television, and what would come out in the press would often be very different from what I'd see every day in court. That you had a kind of refusal to acknowledge what was going on, and a sort of gloss on things. Up until, I think, day 6 of the trial, we didn't know if Malema would testify. He didn't have an obligation to. And at a certain juncture, they thought they're going to need him to rebut some of what's happened. And so they called him, and they called an expert on speech and on struggle songs. And a lot of the really interesting material that I think people have focused on afterwards is Julius's testimony. His testimony in chief from his counsel is quite short. And I then cross-examined him for 2 days. And part of that was to try and understand the FF as a movement. So about the first couple of hours of my cross-examination, focus on what is this movement actually about. And they describe themselves as a Marxist, Leninist, Fanonist movement. So there's a sense that they are the vanguard. They must have total control over all levers of power, that no one should have property rights, that everyone must basically reside as a serf who will be doled out access to property and resources by them. They wouldn't use the word serf, but the rest of it they would agree with. This is much part of the movement. And that is that as the vanguard, we hold things on behalf of the people.
The very opposite of freedom that they claim to espouse.
Yes. It's sort of like if you look at countries that have the word democratic in their name, they're often the most despotic. The democratic North Koreans and the democratic Congolese, are not particularly democratic. And one of the things that we'd pointed out about Mr. Malema is that he's an incredibly autocratic leader, which has sort of come out since, as many people have deserted the party and have described it as a cultish organization centered around him. But so part of it was to try and understand, well, what is the movement about? What do they want? Are they a genuine threat? Is this an organization that South Africans should be worried about? And so I wanted to draw out a lot of testimony from Mr. Malema. It's interesting, some of the things that people have sort of said to me, if I look at online commentary, they sort of comment that I'm very calm in the cross-examination process, and some people are upset that I'm calm. I think, why didn't you climb over the table and hit him in the chops, And I sort of, one of the decisions we'd made early on was it's important to give him enough rope to hang himself. That understanding what the movement is, understanding what they believe is very important, because then when you know what it is that you're facing as a genuine threat, and letting the words come out of his own mouth. And it was a little bit like trying to pick a lock, trying to work out what are the right questions to ask him so that he would implicate himself. And I realized that he found himself caught between two poles. On the one hand, he wants to try and escape the hate speech charges, and so to try and talk down the dangerous rhetoric. And on the other hand, he's a politician who's trying to build up political support. And so if he came across as too moderate, he could be abandoned by supporters who would call him a sellout. So that once that became apparent, I would then push him in a certain direction. And he makes a number of stunning concessions. So the one is he says, when the time comes, we will bomb the union buildings. He said that, in order to overcome the structural violence of things like colonialism, we need to use real violence, and we should never denounce violence. It's an important part of the revolution, and the revolution is now. When I asked him, what does the song mean? He said, well, it is a command to the soldiers, being Namazane, to go out and to kill. And I said, well, and who are the Boers? And he says, when I think of a Boer and I think of a farmer, I think of a white person. So he was quite unequivocal in saying the target of the song are white people, are Afrikaners. The song is an instruction, so in other words, an incitement. A lot of these guys kind of walk around in military-style fatigues as well. So you'll sort of see that the EFF have two kinds of uniforms, the red workers' uniforms, and then there's the kind of combat fatigues with the berets. So there's a sense in which they see themselves as soldiers in the movement. And you have various real-world examples of people being killed, and Kill the Boer being chanted or painted in blood on the walls.
And even in their own constitutional documents, they say that they're explicitly a violent revolutionary group.
Yes. It's an interesting thing that Gareth Onsland said to me a while ago, which is he takes the unusual approach of believing politicians when they say things. And I do think that often these kinds of movements tell you what they are, quite proudly. They don't hide what their agendas are. They might have a bit of doublespeak, and maybe they sort of change their tone for different audiences. But there's a sense in which the EFF broadcasts its view. So what is interesting about the case, and I'll tell you a couple of interesting anecdotes about it, but when it came down to the judgment being handed down, the EFF's legal team didn't arrive. So the way that judgments are handed down, in some cases that you have a presentation from the judge, so they read out the judgment to you. And our suspicion at the time was that they thought they would lose, which is why they weren't there. And I think they were very surprised to have a judgment in their favor, given how the trial had gone.
Sorry, Mark, just to interrupt you there before we get to the judgment. You mentioned the example of him speaking about the union buildings and the song being in order, but for me, the more unequivocal kind of moment, and again, you said like this all hinged on what is the context of the song, what does it mean? And I think the judgment also focused on that. What does it mean? How would ordinary people kind of see this? But there was a point where you asked him about a television interview that he did at some stage, where the reporters were asking him about the song. What does this mean? And they said, do you understand? Do you understand why people might feel a little bit ambivalent about you singing these things, chanting these things? And he said something about their crybabies. So he doesn't care what people think, Julius Malema. And the reporter pushed him a little bit more, and then he effectively said, listen, don't worry. We are not calling for the slaughter of white people, at least for now. And you asked him about that, and any reasonable person would think he would walk that back and he would say, yeah, look, it was a moment of jest, or I didn't mean it that way, I was speaking metaphorically. No, none of that. He said very clearly, listen, yeah, I stand by what I said. I am not at this moment calling for the slaughter of white people. And then I think you saw a grand opportunity, and to me, this is the killing blow. In any other court in the common law world, this is the moment where Julius Malema lost the case. You said, okay, good. Here is an opportunity, Mr. Malema. Please pledge to the judge, sitting right there, 2 feet away from you, and to the country, that you will under no circumstances ever call for people to be killed on the basis of their race. And I think he misheard you the first time, but a second later he clarified and said, I will under no circumstances make such a pledge. I will not do it. Now, as far as I'm concerned, that is it. Done. He has conceded his whole case. He has turned to the judge and said, yes, my lord, the song means we want people to go and kill people on the basis of their race, and here's all the evidence, I admit it. He did not lose the case. So, I mean, maybe go a little bit into what was the court's judgment, bearing in mind what I just said, what Malema said, and what you explained earlier about what he said. But what was the Equality Court's judgment, kind of in essence, in that case?
Well, I'm glad you brought up this piece of cross-examination. So after I'd run this case, I ran another case around the ANC's cadre deployment policy. And to prep for that case, I had to read through a lot of the Zondo Commission cross-examination. And one of the things that I noticed there was that a question would be asked, you'd get an answer that was incomplete, and the cross-examiner would move on. And I thought the way they prepared for this case was that they wrote down their 15 questions, and they read it out, and then they got an answer, and they said, okay, next question. And the way that I prepared for this case was to really think about themes, and to be very in the moment. And I think to be a good cross-examiner is to listen incredibly carefully to what your witness has said, and to keep asking uncomfortable questions. Part of my training's in philosophy, and I run this philosophy discussion show. And one of the things about philosophers, why we make bad dinner party guests sometimes, is that if someone gives an ambiguous statement, we say, well, hold on, what do you mean? And we try and pin them down, and we'll do it beyond the point of politeness to find out, what do you actually mean? And so when I asked Mr. Malema, will you pledge? He says, yes, I'll make that pledge. And I could have stopped there, but I said, okay, well, in the abstract, you've said you'll do it, make the pledge. And that's when he refuses. And I thought asking that extra question was the decisive killing blow. As you say, it should have been the killing blow. What the court found, there are a few astounding things. The one is I mentioned our bevy of experts, and the court said that all of their evidence could be ignored on the basis that it didn't show a causal link between the speech and real world violence. Now, as I say, the quality judgment had been handed down before. I had drawn the court's attention to the fact that our test was never to meet that hurdle. That had been raised by my opponent, and I had specifically rebutted and said that is not what we have to meet. And the purpose of this evidence is to provide context. The Constitutional Court had handed down a judgment in Masuku, which also sort of entrenched this idea of what is the purpose of experts, and we met that requirement. So that's the one finding. The court sort of says, well, we can ignore all the evidence. And then the court does a very interesting exercise in interpreting the meaning of the song. Now, I mentioned that the FF had one other witness, Professor Gunner, who was styled as a sort of expert on struggle songs. And it was the last day of the trial, I sort of expected that, after the cross-examination of Mr. Malema, that, this would be a bit of a damp squib, that she would make a couple of concessions and, that's how it would end. And it wound up becoming very, very fiery, partly because her answers were just so divorced from reality. There's a point where I said to her, you're an academic who's got quite a regal career, published in many occasions. Why would you sacrifice your career by giving the kinds of answers that you've given today, which are just so revolting and so detached from reality? And she was willing to justify any kind of speech for the sake of the movement, was the impression that I got. And it was sort of seen as rather laughable. I mean, she got attacked from everybody online who were just sort of like vilified, horrified by what she'd said. And the judge kind of, if you read the judgment, you would have thought you had this world-class expert who'd solved the problem for him, which is also a dereliction of duty, because the requirement in our law around the interpretation of hate speech is that experts can't tell you what the words mean. So the role of the expert is to give you a context in which the words appear, but they can't say this thing means this. That's the judge's job. So the judge does come to his own interpretation, and one that none of us had heard in court. No one had argued for this, which is that Boer doesn't refer to Afrikaners. It actually refers to the ANC, and that the song was meant to show the EFF's distaste with their ANC's failures in land reform, which is an astonishing finding. Gareth van Onselen did a poll recently for, I think it's for the Social Research Foundation, where they ask people, what are your views on the case and what do you think the thing means? And that was one of the answers people could select, and it's the one that came last. I think among EFF supporters, most of them took a rich literal meaning, that it was actually an attack on Afrikaners. So that was the finding. It was sort of quite flabbergasting in many ways, seemed to be a big departure from our prior precedents in it. I've been doing hate speech litigation now for about a decade, and very much with an aim in mind, which is that free speech really matters. It's important for people to express their views, even if they're offensive, but that there are some hard limits. And once you start calling for real-world acts of violence under circumstances where there's a good chance that they will eventuate, which again, not even a requirement in our law, but then we should be concerned. And so when you have a powerful politician, with a lot of the electorate chanting these songs at stadiums full of 90,000 people, you should be worried about it. Whereas maybe you should be a little less concerned about retired estate agents, who say things you don't like, who have no power base. So we've kind of had this disjuncture in our law in terms of who actually gets punished and what for. The cynical view would be that you can ignore all of the principles, that there is no golden thread in our law whatsoever. It's just a matter of going, who's the perpetrator, who's the victim, and what groups do they belong to, and that'll tell you the answer. And that there's a few deviations from that, but not many. One of the cases that I ran was against a guy called Valapi Kumalo, who was an ANC official, and he said, we should do to white people what Hitler did to the Jews. They should be burnt alive, hacked to death, and their children turned to garden fertilizer. And I acted for the Human Rights Commission in this matter, who were at many junctures quite keen for the case to go away. And there was a sense that, well, he's one of our own, not a member of the Human Rights Commission, of course, but a member of the ANC. And the case sort of could have collapsed on many occasions for various reasons, but we persisted. And ultimately the finding was that he would be liable. We also heightened up the free speech protections. There, Judge Sutherland had said you can't have hurtful speech alone, that you must have propagation of hatred and incitement of harm, and the speech is harmful. So he took one interpretive approach, which then protected free speech and said, and in this instance, this is a case where the speech shouldn't be allowed. There was also a sense in which he thought the kind of penalties that we've been seeing at the time, which were these lofty fines, about 250,000 Rand, he said that seems inappropriate, and he required an apology, but no fine. And specifically says that we can't have different rules for different races, that whether you're white, whether you're black, whether you're ascendant or descendant, like the law must operate equally. And that's a very important principle, and one which I would then argue in later cases.
Yeah, in many respects, it was an indictment, that case, of firstly our political culture, that this kind of violent rhetoric is tolerated. It was also an indictment of the media, that anybody who watched the live stream would be able to see with their own eyes exactly what was happening. And yet the edited version that you saw in the newspapers or in curated videos revealed somebody in the person of Malema who just cared about social justice and achieving racial equity, leaving out all of the nasty bits, all of the calls to violence. But unfortunately, it was also an indictment of the court itself and the judicial system, which seemed to abandon any pretense at impartiality or independence. The case then moved to the Supreme Court of Appeal. We then came in as an amicus curiae, as the Free Market Foundation's Rule of Law project. We got you on brief. What did you argue before that court, and what was the consequence of that phase of the litigation?
Yes, so I mentioned earlier this idea, from the court in Kamala, that you must have the equal application of the law. And so what I'd argued for the Rule of Law project was that the rules were changed for Mr. Malema. That, if the ordinary rule is these people count as experts, in the AfriForum case, suddenly those people aren't experts. That if the rules were you don't need a causal link, suddenly you need a causal link. And that inequitable application of the law is an incredibly dangerous principle, that we must have a precedent-based system where you have certainty, where you can prepare your case knowing what the legal regime looks like, especially when you have a hierarchy. So when these decisions are made by the Constitutional Court, lower courts are bound. They have no room to deviate from it. If it's from an equivalent court, they are presumptively bound, but they've got to explain away why they're departing from the principle. Here you had none of that. So the exact same kind of style of experts are used as in Kwalani, but suddenly they're not experts. And so we were quite forceful in our view, and also said there's a concern that some members of society will feel that they are completely at license to say what they like. If you are a powerful politician, you will say, I will not be held accountable. I can call for people to be murdered on the grounds of their race. I can engage in what someone would describe as genocidal speech. Whereas if you're part of a racial minority and a bit of a nobody and not very powerful, you might think, well, geez, I'll say the wrong thing. I'll be dragged to the courts, I'll be bankrupted, I'll be humiliated. I better not say that. And once you start to do that, and that gets authorized by courts, you break down societal trust. You break down people's trust in the sense of we're all South Africans, we're in this together, we all have equal rights, we all have equal dignity, we all have equal freedoms. And you start to feel that these authoritative bases have picked a side. Interestingly enough, the Constitutional Court had looked at the issue of what happens when you have a powerful politician speaking. And they've said you should have heightened scrutiny. It's not a matter of saying, let them off the hook, it's merely political speech. They said if someone commands that much authority, you must take it into account when evaluating the speech. And they'd adopted something from the rebut plan of action, which was a sort of international law test. So this is not just a South African thing, it's internationally recognized, but was severely departed from by our courts. There was a further complication in that case, which is that one of the judges in the panel, so in Supreme Court of Appeal you have 5 judges, was an acting judge, so a judge in the Gauteng, but basically serving on a temporary basis at the Supreme Court of Appeal. This is Justice Keatley. And at the end of the argument the following day, one of the attorneys for AfriForum had sort of tuned in to watch the proceedings. And again, so these proceedings were filmed, which is very useful for the record. And they said, I know that name. How do I know that name? And they looked back in their records and they said, we've actually appeared before Judge Keatley before. And she had made an astounding proclamation, which is that she said, if you, AfriForum, ever appear before me again, I strongly suggest that you ask for my recusal.
And this was in a separate case on another matter.
On another matter. And had sort of expressed distaste for the kinds of values that AfriForum stood for. And it specifically raised the idea of recusal. So AfriForum then brought a recusal application. And the way you do that is you first approach the judge themselves and you say it's a matter of your conscience. The test is either are you actually biased or is there a reasonable apprehension that someone would think that you're biased?
Like a perception of bias.
Exactly, a reasonable perception of bias. And there was a decision to have a full-blown recusal application, which was then heard by the other 5 judges. And I would say that that decision fundamentally changes our law on recusals, in that Judge Keatley was not required to recuse herself. And then the full decision was granted, which dismissed AfriForum's case, and took no heed of any of the kind of equality before the law principles that had been raised by us. And I think that I had colleagues come up to me and say, you know what, Mark, I'm a big supporter of the EFF. I don't like Afrikaners. I actually think they deserve death. But what happened with Judge Keatley, that's beyond the pale.
That's quite an indictment.
Yeah, so there was a strong view that, you know, if you're meant to take recusal seriously, like, this seems strange. Judge Keatley is now a permanent member of the Supreme Court of Appeal. One of the things that sort of makes this complicated is that Julius Malema is a member of the Judicial Services Commission, and so plays a role in picking those judges. He was not present on the day that Judge Keatley was made a permanent judge, and there was another aspirant judge who was also made a judge of appeal that day, being David Ansara, who Julius Malema had said on many occasions that he was the reason why Judge Ansara was not being elevated to the SCA, because he had sort of like a personal animus against him, and that had come out in transcripts from the JSC proceedings where Mr. Malema had accused Judge Ansara of being a racist without any basis for doing so. So yeah, there's a sort of risk when one of the litigants in proceedings has the power to change the prospects of, you know, judges' careers. So, well, if you want to be elevated, you know what the right thing to do is. One of the other judges on the panel, Motajane, when he was a High Court judge, had found against Mr. Malema for a defamation case against Trevor Manuel and held him liable for R500,000. And when he applied for elevation, Malema said to him, "Why should I give you a promotion after what you did to me?" It was as sort of like transactional as that. And Parliament then asked Malema to apologize. He refused, got an interdict preventing the apology, was successful in that. So you have this sort of like just brutal acts of power that seem to shape the kind of decisions. And when you have that, it taints the judicial process. That if people feel, if the first question you're asking yourself is, who's my judge? That's a worry, as opposed to saying, regardless of which judge I draw, I know that they're going to impartially apply the law, even if it's different to their personal values, whatever their personal political beliefs are. I know that they're going to look at the law as it stands and they're going to apply it. And I don't think we have that.
Martin, you and I were sitting in the gallery that day at the SCA, observing the proceedings. What were some of your observations?
Yeah, so I've always been a bit of a cynic when it comes to our courts. On the drive to Bloemfontein, I told both you and Mark that I fully expect us to lose the case, and I was vindicated, much to my sadness in that respect. But what I experienced from the panel was more or less what I thought I expected. There was a lot of so I'm not a practicing lawyer, but I really experienced a level of warmth. A high level of warmth from the panel towards the economic freedom fighters and their counsel, and a level of coldness, the exact opposite, displayed specifically not towards us necessarily as the Free Market Foundation, but certainly towards the main applicant, AfriForum. So that to me was quite tangible in the air on the day, and one of the manifestations, for instance, of that was that one of the judges almost took an argument from the EFF playbook, and this is this idea of, do you really want to ban this song for everyone? What about when we have a funeral for some struggle hero and kind of in remembrance of the good role that they played, we sing this struggle song. Do you really want to do this? Kind of proposing this question almost to those of us who say there shouldn't be kind of calls to genocide. And the reality is no one was asking for Kill the Boer to be banned in the abstract as this kind of thing that people do, and you're not allowed to utter these words in succession. The court has done that with the old South African flag, though, so there's a kind of a level of hypocrisy there from our courts. But that question was never on the table. There was no plan to ban Kill the Boer in the abstract. There was plentiful evidence introduced at the trial in the Equality Court to say, when Julius Malema on these occasions said, or he chanted, or he sang this song, he did in fact mean what he was saying sincerely, and he admitted to it in cross-examination in the court. And that was just completely ignored by the bench. And that was very obvious that day as arguments were being led. And kind of the judgment that I expected to lose, I didn't quite expect what I would characterize as utter nonsense in the Supreme Court of Appeal's judgment to come out, because I did expect that there will be some level of interrogation of the evidence that was in the record from the trial court. But just like in the trial court, that was all discounted. Everything Julius Malema testified to, admitted, conceded, none of it came out. And the court, I'll let you, Mark, speak on the kind of the exact ambit of the judgment, but the court effectively just said, listen, he doesn't mean it. And no reasonable person out there thinks that he means it, even though we've now asked the Americans, we've asked the Europeans, we've asked everyone in the streets. Everyone understands what's happening with the survey you mentioned. Every reasonable person gets what is being said. It is only that small section of our intelligentsia, which includes the EFF and our judges, who want to contrive some benignness to what's happening.
Yeah, you've said a number of things that are worth addressing. The one, as you say, was working out, do we have blasphemous words in South Africa, where you say you can never say this under any conditions? And it seems that the answer is yes and no. So on Kill the Boer, the idea was to say, well, obviously you must look at the context, and I agree, there's going to be cases where I'm going to mention that phrase, and no one thinks I'm inciting violence by doing so, right? There's a use-mention distinction. The occasion is going to make a difference. If you have, a museum where you sort of had an example of struggle songs, fine. In the same way that you can go to a Holocaust museum and you'll see images of swastikas. They're not there to valorize the Holocaust, they're there to, expose it. But as you mentioned with the South African flag, when I argued that case to say, well, you really have to have a context-sensitive approach, you cannot have an outright ban, the Supreme Court wasn't interested at all in that idea. And we largely have a ban, barring some exceptions. But the idea that it could be determined in the abstract, they were very happy with. And so that double standard, again, is a huge concern. What's interesting about the case, so it's then started to gain a lot of sort of political traction. I think after the election of Donald Trump, the Americans started paying a lot more attention to South Africa and sort of looking at South African government's various misdeeds, its ill treatment of minority groups, its failure to declare farm murder as a priority crime, its indulgence of this sort of speech. And while that conversation was going on, the application for leave to appeal was sitting on the Constitutional Court's desk. And
from the Supreme Court of Appeal,
yes.
After that case was lost and they rendered their judgment, AfriForum appealed that judgment and it applied to the Constitutional Court. So this is the stage.
Exactly. So there was a period where basically people were waiting for a date to be allocated by the Constitutional Court, and I would check in with them on, every couple of months, say, when is this thing being argued? And then sort of during, as I say, this level of heightened international scrutiny at a time when people were becoming more and more internationally horrified about Malema's conduct, the Constitutional Court refused to hear the appeal and produced sort of pro forma, which says there are no reasonable prospects of success and the appeal will not be entertained. And I think that was a very shocking moment for a lot of South Africans, because there is a general belief that the Constitutional Court is the upper guardian of all of us, that our Constitution is applied impartially, that the Constitutional Court has a history generally of entertaining matters of this sort. It's clearly one of massive public import. It deals with a fundamental right around free speech and dignity and equality. And so one would expect it to have weighed in. Also, its prior jurisprudence tends to find hate speech. So this was sort of seen as a rather shocking pronouncement. But quite soon after that, you then had this sort of South African delegation go off to America and try and repair relationships with America. And at some juncture, Donald Trump utters the wonderful phrase, "dim the lights."
Natalie, dim the lights. I don't know who Natalie is, but she did his bidding.
And at that juncture, he shows a video of Kill the Boer being sung on various occasions by the FF, a lot of the footage that we had used in the trial, and then also a memorial of crosses that had been put up in their thousands, and cars sort of like lined up for this sort of temporary memorial that was set up. And at that juncture, it occurred to me that we had run the best art of the losing case imaginable. That if the purpose of the litigation was to expose the sort of scourge of farm murders, to expose the FF as being a hateful movement that posed a genuine danger, that moment could not have been dreamt of in the beginning of our litigation. The idea that the President of America would berate the President of South Africa because of this incident is the greatest possible success that you could have on that front. And one hopes that it leads to genuine reforms. That I think there's been a lot of coverage about farm murders since. The international press are more concerned. Obviously you'll have people who don't like Donald Trump and also would kind of downplay the farm murders and the attacks. But I think for a lot of people, their eyes have been opened. And so the other case that's sort of most well known as strategic litigation, sort of births strategic litigation, was an early case run by the American Civil Liberties Union, which was called the Scopes Monkey Trial. And it was initiated in 1925. There was a law in Tennessee which forbade the teaching of evolution on the grounds that it contradicted the tenets in the Bible. And the ACLU were quite concerned about the sort of free speech implications of this. And so they found someone who'd be willing to put their hand up and say, I broke the rule. And so they found Mr. Scopes. And he sort of, this case was run between these two quite big legal giants. A film later was made called Inherit the Wind about it. And why it's called the Scopes Monkey Trial is that you had people sort of, having chimps around saying, these crazy liberals are saying we're descended from monkeys, how dare they? And the way that people remember it is they say, and the good guys won, right? And evolution was allowed to be taught in schools. They didn't. They lost. And it took until 1967 before the law was overturned. But in the public imagination, the view was that ultimately the right result was achieved. It took a long time, and often I think the arc of justice bends long, and it's frustrating when you're in it. But I do think that that case inspired a lot of other strategic litigation. And there's a sense in which in South Africa we live always on the cusp of hope and despair. That we have many times when we just want South Africa to live up to its vision, to live up to its constitutional promise, and we get let down on many occasions. But evil triumphs when good men do nothing. It's hard being a good man when you have to fight this long, eternal struggle. You don't ever win freedom. The price of freedom is constant vigilance. And so one has to keep it up, keep litigating, keep pushing forward. But you might win in ways that you don't expect. I remember I gave a sort of a vote of thanks to Ernst Ritz at the 926 Club long before the Kill the Boer trial. And I said, there's a famous line from Gandhi where he says, first they ignore you, then they laugh at you, then they fight you, and then you win. And I think that's where we found ourselves with Kill the Boer.
Well, Advocate Mark Oppenheimer, I wanted to thank you very much for sharing your story and also your reflections on this seminal trial. And I think what I've taken from this conversation is that there is the court of justice, but there's also the court of public opinion, and there's also the long game that needs to be fought. And there are different arenas of contestation. The courts are a very important arena in themselves. It's not the only arena. It's necessary but not sufficient in the battle for freedom in South Africa. But you are a warrior for freedom, and we salute you and your work, and we're very privileged to have you collaborating with us on this very important principle of the rule of law in South Africa, a principle worth fighting for, and one which you do with great clarity and conviction and courage. So thank you very much.
Thank you.
Thank you for watching this conversation with Advocate Mark Oppenheimer. A special thank you to Sakeliga for making this production possible. If you support the work that we are doing here at the Free Market Foundation in terms of strategic public interest litigation as well as our advocacy, I'd encourage you to support us financially. There's a link in the description below. And if you can't donate to us, you can please hit the like button, subscribe to this channel, and also share it with your friends and family. My name is David Ansara. This is the Free Market Foundation. Remember, stay free.